So again, today we're going to be talking about marijuana and CBD law. And so just so people know, we're really going to get more into specific as far as state here in the state of Texas and local Harris County, Fort Bend area, because you know a little bit about federal, but not too much, but pretty knowledgeable when it comes to state and local, correct?
Correct.
Okay. So as it sits right now currently, give a little background as far as current Texas. Well, is there a big difference between Texas state law and local municipalities and county law? Is there a big difference there, or is it just a difference in how it's enforced?
How it's enforced. It's
Okay.
state law rules. There is no municipal laws that relate to marijuana.
Okay.
It's all state law based.
Okay.
It's just how each county deals with the charging and punishment of possession of marijuana.
Got it. Okay, so the enforcement is the county and local level.
That's right.
Okay. So current Texas marijuana CBD law, what is it currently?
So marijuana as we know it, green leafy substance, is illegal in the state of Texas. So it's illegal in the state of Texas. It's legal in about 13 states, maybe 12 states for recreational use, as well as some states are medicinal use. As we sit today, marijuana is legal in Texas. So
It's illegal in Texas.
Illegal in
Okay.
Texas.
All right.
So marijuana, as we think of marijuana and the smell that you associate with marijuana, that we've known and seen our entire life is still illegal in Texas. So anything under 2 ounces is a Class B misdemeanor, a minor misdemeanor offense. Anything between 2 and 4 ounces is a Class A misdemeanor, still low-level county jail punishment. And then once you get over 4 ounces, you start getting into felony-level possession of marijuana. That's where you pretty significant amounts, up to 5 pounds is a state jail felony. And then you go up to 50 pounds as a third degree, then up to 2,000 pounds as a second degree, and anything over 2,000 pounds as a first degree felony. So you start getting pretty significant punishment ranges when you starting getting truckloads full of marijuana.
Okay. And at that particular time, it doesn't matter. They don't classify intent to distribute or anything like that. It's just possession, correct?
They don't have intent. So
Okay.
cocaine, methamphetamine, PCP, heroin, all the high-level drugs that we think of, there is an intent to distribute. That they could charge you if you have a large amount and say you have scales, you have baggies, you have large amounts of money with you. They can charge you with possession of methamphetamine with intent to deliver. So methamphetamine's a certain level. If they add the intent to deliver, it bumps it up 1 degree, so it increases the punishment range. Marijuana doesn't have the intent to deliver. They do have delivery. So you can have possession of marijuana. If you have 2,000 pounds, they can't charge you with intent to deliver. But if you are delivering marijuana and they catch you selling it, then they can charge you with delivery, which again ups the punishment range 1 degree. So it's a little bit different than the possession of meth and cocaine. There is no intent to deliver for marijuana. It's actual possession and or delivery. The intent doesn't matter for marijuana.
Okay, well that's it. I didn't know that. So no matter what, there's never, unless it's you're actively seen doing it as far as distribution goes. With marijuana, even if it's in your possession, like that's all you're getting is a marijuana possession charge.
That's right.
So if you have a bunch of baggies or it's broken down to 10 little bags, there's no intent to distribute?
There is no intent.
Wow.
Why do you think they do it like that?
I think because it's marijuana, and it's not
Okay.
what people, our legislators think of as highly addictive or drugs associated with violence,
Okay.
maybe. I don't know. It's been like that since I've been practicing law. So back in 2001, it's always been either possession or distribution. There is no intent to deliver marijuana.
Wow, I never knew that.
I didn't either.
That's
And oddly enough, we see a lot of cocaine, methamphetamine possession with intent to deliver because of the amount or the baggies or the money. We see that all the time. Charged. I mean, not a lot of times that we plead to it, but it is charged quite a bit.
okay. All right. So what has changed as far as the enforcement goes in relation to marijuana possession here locally, Fort Bend? And when I'm saying locally, Fort Bend, Houston area, Fort Bend
surrounding
County,
counties.
Sugar Land and Fort Bend, Houston and Harris County. What's changed there as far as the enforcement?
Yeah, and my question is, so across the state, it's the same law. It's just a matter of who is enforcing it and which counties aren't enforcing it.
That's right.
Okay.
And it's kind of the policy of the district attorney for that county and how they want to handle individuals charged with possession of marijuana. So Harris County, the amounts are, I don't know exactly the amounts. I think it's less than 2 ounces that they write a ticket.
That sounds right.
And it tell you to appear in court.
Let me ask you this real quick, just for people. Sorry to interrupt, but when you say 2 ounces, I know for sometimes people are just like they can't wrap their head around what 2 ounces. What would 2 ounces look like? Just basically like one joint that somebody has.
Yeah, that's less than 2 ounces. You can usually get like a sandwich bag.
Okay.
It's not stuffed completely full, but most of the time in a sandwich bag, that's typically less than 2 ounces.
Okay. All right.
So if you get a gallon-sized bag, you're kind of pushing 4 ounces. You know, you're kind of getting in that dangerous territory of getting up to a felony level offense.
Okay. All right. Sorry to interrupt. Go ahead. So you were talking about as far as the enforcement.
So Harris County, DA's policy is less than 2 ounces, you write a ticket, and then they have the ability to take a class and the case will be dismissed.
Mm-hmm.
That's the only county that I'm aware of, surrounding county that does that. Brazoria County still enforces, still arrest. Fort Bend County still enforces and still arrests for any amount of marijuana. So Harris County is the only one that does that. I know Fort Bend County, with the change in administration, they are going to start implementing a new policy, but it's going to be implemented in court, not, as I know it now, not implemented with law enforcement on the scene, only in court, where they're giving them an opportunity, if it's a first-time low-level marijuana case, to take a class, a drug class, do some maybe some community service, and the case gets dismissed.
So you're still going to get locked up in Fort Bend even when they enforce that, but in court is when they will lessen the sentence for you?
That's correct. So you're going to deal with an arrest record for, a year or two until you get the case dismissed and you can get it expunged.
Okay. How difficult or easy are they making that as far as getting it off your record?
It's fairly easy. If you do what you're supposed to do and the case gets dismissed, I've never had a hard time getting expunged off a record. The DA's office has been very agreeable to things like that, and we file those motions all the time to get these arrest records off the record.
Okay. And when it does get expunged, is it truly off your record to where nobody can see it, or is it still visible by people?
If you do a good job on the front end, if you find an attorney who knows what they're doing and knows who to serve, 99% of the time you can get it completely wiped off. But you have to serve every single agency who ever touched the case. The county clerk, the prosecutor, the sheriff's department if they made the arrest, the FBI because of their database, DPS because of their database. And sometimes you have to serve individual companies who you pay to get criminal history checks done. Like if you go apply for a job, a lot of these employers use a company who has a database and they check criminal records. Well, if their database hasn't been updated, then that record hasn't been wiped clean. So say someone bought a database 3 years ago when you've been arrested, but in the interim you've had it expunged off your record, they haven't updated their database, that arrest record is still on their database. And so they report back to the employer, I'm showing an arrest for possession of marijuana. And they ask the kid, have you ever been arrested or charged with marijuana? No, because the kid can legally deny it. It's been expunged, but they haven't updated their database. So sometimes you get in there, and if we see those situations occur, then we have a judge sign an order and we serve that company to take it off their database.
It's one thing for the judge to say it will be expunged or fall off your record, but it's a whole nother process to actually execute that paperwork to make sure that everybody takes it off.
Absolutely. I mean, we have to serve every agency. Some of them now locally, to make it easier, will allow us to serve them via email. So they'll get the judgment to expunge the records via an email. But if they don't allow service by email, we have to serve them certified mail return receipt, which the clerk has to send, which can get a little pricey. It's $20-$30 a agency. And you could have 15 to 20 agencies you got to serve to make sure that they get a copy of the judgment and they follow the ruling of the court.
Okay.
Well, it's good to know. That way you just don't automatically assume it's just going to fall off and nobody's going to see it.
No, you have to. If you don't file a motion to expunge, that arrest record will stay there forever.
Wow.
Even if the case was dismissed.
Okay.
It's still on your record.
And that's dependent upon the counsel that you have and the good work that they do to get that done, right? I mean, you can't just assume that whoever it is that's defending you in that particular case, they're just going to get it done.
Right. I mean, you have an attorney and they don't do a very good job and they don't serve DPS with the expunction order. Well, everybody gets a criminal history from DPS. Well, it doesn't matter that you serve the clerk or the sheriff's department or district attorney's office and they destroyed the records. The main database is DPS. They don't serve DPS. All the other work you've done is worthless.
Okay. So that's why you have a good attorney like Smith, McDonald, and Bolin to help you out in that case, correct?
Well, we do them all the time, so I hope
good.
we do a good job.
That's good. So in the enforcement part of it, is it when you're traveling through counties, let's say you're traveling through Harris County, you're traveling through Fort Bend, is the enforcement of that, like you're in Fort Bend or you're in Harris County and you're driving in the Fort Bend and you get pulled over less than 2 ounces of marijuana? I mean, how does that play out? You know, I mean, you're a Harris County resident, you're moving through Fort Bend County, like how does that kind of stuff play out?
You know, it first starts with how local law enforcement on the scene want to handle it.
Mm-hmm.
You know, we talked about in a couple podcasts ago that, you know, it's a little stronger enforcement now than it used to be with, you know, DWI. Sometimes the officer would take you home, or you'd have marijuana. Sometimes they would throw it in the gutter or flush it down the toilet and they'd let you go. That still happens. Some officers will let you go if you say you're an 18, 19-year-old kid, you're cooperative, you tell them where the marijuana is, it's an extremely small amount. He may just say, look, I'm going to let you go. I'm not going to arrest you for this. Don't do it again. And that's the end of it. And he, you know, takes the weed and turns it in, but doesn't file charges.
Okay.
That can happen. I don't know how often that happens because we never see those situations because they never come to us. They're never charged.
Right.
But it does happen.
Okay.
But if, you know, you come to Fort Bend County and the officer wants to arrest you, then he's going to arrest you. I mean, there's a difference in Fort Bend and Harris Counties. Harris Counties has to give you a ticket. Fort Bend County essentially has to arrest you unless they use their discretion just to completely release you.
Okay. And you're saying ticket like you would if you got a speeding ticket, basically.
That's right.
Okay. And it gives you time and a place to go in front of a judge and just like that. Okay.
So in Harris County, when they give you the ticket, do they take your weed?
Yes. Yeah, they take the weed.
I was just asking.
Right. Well, no, because you're thinking about, I mean, when you get I say in reference to a speeding ticket, when you get a speeding ticket, they don't take your car from you.
Yeah.
So,
wow, that's,
you know,
I think Harris County they give you information where to go take the drug class.
Okay.
And they give you, say, 60 or 90 days to go take the drug class. You go
Okay.
take the drug class, you mail them confirmation, you never go to court.
wow.
So I don't think it's technically a ticket. It's you need to do this in 3 months. If you don't do it in 3 months, then you need to come to court. But if you do it, send us confirmation. We're not going to tie up the court systems with you having to appear, is how I think it is.
Okay.
You would think so, because I think that's the whole
It's the whole point.
reason
That's
of
right.
doing it, is to minimize all of the court time.
Sure. And all law enforcement's time
Yeah.
having to take these guys
all
to
of
jail.
the overhead.
So you don't do that. 3 months, you go to court. What are you expecting to happen to you when you go into court in a case like that? So you didn't do the drug class or whatever it was you're supposed to do. So you go in front of a judge in 3 months. How does that look?
For the most part, I think they are giving you more time to take the class. Like, hey, dummy,
Okay.
Go take the class. You don't want a record. Go
Okay.
take the class. We'll give you another 60 days. Go take
Okay.
the class. Is the general census is what they're doing out of Harris County.
Okay. Do you think that, we talked about it briefly in the last podcast, do you think that's going to happen here in Fort Bend as far as the same kind of general enforcement that Harris County has?
I don't know if law enforcement is on board with the HPD policy.
Oh, okay.
So I think we're still going to work those cases out in court rather than on the scene with tickets and go take a drug class. We're not there in Fort Bend County at this point.
What is it about it that you know of, at least, that law enforcement's not digging that?
Well, I think in large part is they don't like someone taking away their discretion and their ability to make arrests when they deem it appropriate.
Okay.
And I'm a big fan of that. Is I want law enforcement on the scene to have a lot of discretion.
Sure.
Because some kids need to go to jail, some don't. So I don't think we're there yet with taking that discretion away. In large part, it's hard to go tell Troy Nels, hey, by the way, your officers can't make arrests anymore. I mean, that's a process that's going to take years if it ever happens out here in Fort Bend County. So, that's a difficult situation that, I don't know of any sheriff who's done such a good job as Troy has, that somebody comes in and just says, hey, by the way, we're not going to let you make arrests anymore. I'm not sure that legally anybody can tell law enforcement not to make an arrest for violations of laws in the state of Texas. That's the law enforcement's discretion. Now in Harris County, there's an agreement But I don't think that agreement's coming out here anytime soon.
And the agreement is no matter what, if it's a certain level or a certain size, no arrest at all, ticket, and they go on their way.
That's right.
And Fort Bend, you have anything, you're getting locked up, and they'll work it out in court.
Correct.
Okay.
And it's, I can see both sides of it. I can see the saving of the time and overhead and money and not making the arrest. But I can also see the kid getting arrested and having to come to court, that's going to have a much more dramatic impact on an 18-year-old kid than him being detained on a scene for 15 minutes and he has to go take a class online and that's it. That's the only accountability that he has. I think having to come to court, seeing that this is serious, going to jail, being booked in, being around some of these guys in jail will have a much more dramatic impact in trying to get him off that route that he's on. Absolutely.
Yeah,
absolutely. There's something to be said for that.
Yeah. I can see how law enforcement at least, taking that responsibility out of their hands and not letting them. I'm sure they can have some discretion as far as if something looks fishy, right? Like if you have somebody that's got a small amount with them, but something doesn't look right. I mean, they can pursue the steps from that, right? Or do they get to a point where somebody can come back and say, he only had a small amount, they had no right to further the investigation, I guess, on the scene?
I don't think they're there. I believe if you have the marijuana or they smell the marijuana, they still have the right to search the car to see how much marijuana you have, see if you have other narcotics, stolen weapons, anything else, burglary tools, things like that in the vehicle. I don't believe the rules in Harris County preclude law enforcement from continuing their investigation until they're satisfied that they've done what they need to.
What actually constitute them being able to search your car?
Short answer is smell of weed. They smell weed.
Probable cause
to search your car. That's it. And that's a smell of weed. And we have a difficult time with that because, again, we don't know the statistics on how many times law enforcement says they smell weed and they don't find it. And we have no way to refute that they smelled weed or didn't smell weed. It's very subjective. Sure. We can't fight that in court other than the officer's lying, and I'm not ever doing that unless I have some evidence to support it.
Right.
So all we see is officer says, I smell weed, I'm searching your car. Well, he finds weed. It's hard for us to get into court and say, well, the officer made that up. No way he could smell the weed when he found the weed in the car. It's just, you're kind of it's a catch-22.
Well, and sometimes they say that they bring the dog out to sniff the car, and if the dog marks it, then that's probable cause to search.
Absolutely. And there's some timelines in recent case law, not recent, last few years, about times they can detain you to bring the drug dog around, and do they need additional reasonable suspicion other than the traffic stop to further detain you to wait for the dog. So we see that. We don't see a lot of dog searches out here, but we see a fair amount.
Well, I just want the people the audience that are watching to know, actually what that law is or what to expect.
They bring a drug dog out. If they typically ask for consent. If you refuse consent, they're going to talk to you. They're going to try to establish some additional reasonable suspicion, and then they're going to wait for the dog or bring their dog out and walk it around the car. And if the dog alerts, it's probable cause to search.
Sure.
And a lot of times they do that while they're investigating the traffic offense, especially if the dog's in the stopping officer's car. As long as he's still investigating the traffic offense, he has a right to walk the dog around the car, and dog alerts are going to pull you out and search your car.
From your position, if somebody has, whether it's a small weed, big amount, small amount, what should they do in response when the officer asks, do you have marijuana in the car?
Always deny. Always. I've never seen it benefit, strike that. I've seen it benefit my clients, and I make the argument when they do cooperate and they do give consent or like, hey, I got some weed in my pocket. I have seen them get a benefit for that in court. I'll go talk to the prosecutor. I'm like, look, he's an 18-year-old kid. He told the cops where the weed was. He handed it to him. He didn't play any games. He was up front. He was honest. I've used that countless times, and I believe it has helped my client. But do I think that benefit is worth allowing officers to search your car? No, I don't. Officer asked to search your car. No, my attorney advised me not to let you search my car. I have a right to refuse. If you have probable cause to search my car, you can search my car. And I train law enforcement that way. I'm like, always ask for consent. Even if you see a dead body in the back seat that gives you probable cause to search the car, go ask. Hey, do you mind if I search your car? If they say yes, well, now you have consent. We can't argue that you didn't have probable cause. You couldn't really see the dead body in the car or the brick of cocaine in the back seat. Mm-hmm. So always go ask. Always told law enforcement. They always struggle with that. Ask for consent. They give you consent. There's nothing that defense attorney can ever argue in court. Mm-hmm. You're on consent on video, giving them the right to search your car. If you don't ask them for consent and you just go ahead and search and you find a brick of cocaine, first thing I'm going to do is file a motion to suppress it. You could not know from your vantage point that that was a brick of cocaine. You saw a white substance that looked like a brick, but you don't know what that was. No, I don't know what that was. I thought it was cocaine from my training experience. Mm-hmm. Well, I'm fighting that in court. I'm fighting that search.
So if they get into the vehicle without probable cause or without your consent and they find something in the trunk, are you able to get that dismissed out of court because they didn't go through the proper legal procedures to search your vehicle?
Yes. Yes. Not all the time. It happens. Officers are very well trained now. They know. And it's 9 times out of 10, it's a smell of marijuana. Mm-hmm. That's what we typically see, is a smell of marijuana or search warrants. And we can't do much with search warrants because it's confidential informants. So it's,
sure.
Do they have enough probable cause in the search warrant to search your house? And
so in reality, like you said, you don't really have a gauge of exactly you always want to give people the benefit of the doubt that they're going to do what they need to do. But in reality, a cop would come up and say, even though he doesn't, and say, if he thinks there could be something in there and says, I smell marijuana, do you give me permission to search a car? And somebody says yes, and you search a car and you find some stuff, like, you can't gauge on that and say, well, he didn't really smell that, right? That's what you were saying earlier. That's
right. I mean, okay. if he smells weed and
or thinks he does.
That's right. And he says, hey, I smell weed. Do you mind if I look in your car? Rather than, hey, I smell weed. Get out. I'm searching your car.
So if you have that situation where they say, I think I do, can I search your car? At that point, you can accept or deny, and he can't move forward?
If he says he smells it, he can move forward. If he asks you, if he says, I smell weed, can I search your car? He's doing a good job.
Okay. Because
he's protecting himself. He's not going to force us to, he's not going to rely upon the smell of weed alone.
Okay.
If he gets your consent, and I can't fight, you didn't really smell the weed, then it takes out us doing a background investigation, pulling the statistics. How many times has he said he smelled weed and searched a car and didn't find weed? Has he done it 150 times and he's found weed 20 times? Well, if I can pull those records and find that out, that's extremely beneficial to my client.
Sure.
And then I can fight that, well, you didn't really smell weed. But if he gets consent, it takes all my power away.
Okay.
Because my guy said you can look. I can't argue with that. It's on audio and videotape.
Right. If he says, if he walks up and says, I smell marijuana, can I search your vehicle? And you say no, can you say no? And he doesn't, but he's just asking basically at that point just to make sure that procedural part of it is checked off. He can do it no matter what. If he smells it, he's just making sure that's checked off, right?
That's right. He's being smart.
Okay.
He's protecting himself and protecting the case in court.
All right. So if he smells it, it's just your SOL. He's going to look in there.
You're exactly right.
Are all officers wired up with mics and cameras now?
For the most part. And you'll see some malfunctioning cameras, some batteries that go dead, malfunctioning mics. It happens. It's getting more infrequent than it used to. But it still does happen on occasion.
Do you find that you're able to access that footage pretty easily through the court systems?
Oh,
or
yeah. They got to turn it over. They have to turn it over. What we call the Michael Morton Act, or 3914 of the Code of Criminal Procedure. They have to turn over offense reports, videos, statements, written statements, everything. They have to turn over to us now. So we get copies of everything within, if it's a felony, once they're indicted, we get copies of everything, which usually happens within, I don't know, a month of them getting indicted. We got copies of everything. And most of the prosecutors I have a good relationship with them. I can call them and I'm like, hey, have you watched this video? Tell me what it's about. And 99% of the time they're like, either I've watched it and yes, this is what it's about, or hey, give me a few days, let me look at it and let me see. Because I'm like, I have concerns and my guy told me this. Can you look at the video real quick before you go to grand jury and just make sure that everything looks okay? And almost all of them will say, oh, okay, yeah, I'll take a look at it.
Well, those videos got to be really helpful to either, in the case one way or another real quick, whether it's in your defense or theirs. It's going to shut shit down real quick.
Absolutely. I tell my clients that. I'm like, once I look at your video, I'll tell you exactly what I think is going to happen. And I'm almost always right. I know it if I can get you out of it, and I know what your punishment's probably going to be based on your criminal history.
Yeah.
I mean, I can come within, days or months of your probation or your jail time, or if I can get you out of it. And a lot of times, if I can get you out of it, I don't have to go through those steps because the prosecutor's going to have the same opinion, and we'll reach an agreement. like, yeah, I mean, look, I know that was a legal search. You know, I'll go ahead and kick the case. Or, yeah, that was a close call for me. I'll go ahead and reduce this second-degree felony to a misdemeanor time served. So most of the time they're, you know, especially Fort Bend County, which is, I'm the most familiar with, they are, if it's a bad search or it's a questionable call, most of the time they're well above board, almost every time, or well above board, at least with me, and reaching an agreement so we don't have to jump through all those hoops.
Okay, so to end this discussion as far as marijuana goes, what should somebody do in possession and they're pulled over by a police officer?
First and foremost, be respectful.
Okay.
You know, we see a lot of individuals who just don't have any respect for law enforcement, and it typically goes terribly wrong when that happens. So first and foremost, be respectful. Make sure your hands are visible. I'm an advocate of when officers walk up, I don't believe officers like you digging for your license and your insurance as they're walking up. I think they want to make sure that you're not digging for anything, your hands are on the wheel. If they ask for consent, always refuse. Always refuse consent. Do not ever allow a law enforcement, and be respectful. Say, look, you know, I understand you're trying to do your job. My attorneys advised me not to allow you to search my vehicle. If you're going to search it, I'm going to cooperate. I'm sorry I can't give you consent, but I'm just relying on advice of my attorney, and I hope I'm not, you don't feel I'm being disrespectful. Be kind, be nice, you know, because at some point a jury, if we go to trial, is going to see your attitude. And if you want a jury to find you not guilty, they need to like you. You need to be a nice guy. If you're a total jerk and cussing officers out, nobody in that jury is going to be rooting for you. So be nice, be respectful, understand law enforcement's trying to do their job, and what law enforcement asks you to do, you cooperate. Absent letting them search your car with consent.
And so most of these cases or these instances that if you do get caught, you do get locked up, you go to jail, you have to fight it in court, there's always going to be video and audio provided that's going to help your defense or go against you.
Vast majority of times. I mean, we see some malfunctions, but
other than the malfunctions,
by large part,
audio and video is going to be there.
Every single agency has it now.
Kill them with kindness, politely decline, and you'll get to use that footage to also help back you in court.
Absolutely.
Which could play into your favor.
You're not going to win that fight on the scene. Never are you going to win the fight by being an asshole to law enforcement. You're just not.
Sure.
They're not going to be like, oh, you're a jerk, I'm going to let you go.
Yeah, man, it's common sense.
Right. So be polite, be kind. They're trying to do a job. They're not out to get you, you know, and cooperate the best you can without giving consent.
Cool.
Okay.
Well, be nice to the cops out there.
Yes. Yeah. I always get surprised whenever I see people and they yell and holler and scream, and I don't know. Like you said, I think that was funny when you said they're not going to go, oh, okay, well, you're right, I'm going to go ahead and leave you alone.
Right. I mean, I think law enforcement's going to work harder to try to find a violation of the law than if you were polite and kind and nice.
Sure.
So, you know.
And that's what I learned too, or at least I heard, is don't make their stop memorable. Like if it's very boring and very bland, and you said yes sir, no sir, yes ma'am, no ma'am, here's this, here's that, okay, you know, whatever. It's not as memorable a stop, I guess.
And that's the first thing I tell a prosecutor. If my client is extremely nice and courteous and respectful, like we talked about, that's the first thing I say is like, hey, if you watch this video, my client is really respectful. He's really kind. You know, no, he didn't give consent and they smelled weed and they found it anyway, but you know, that's something to his benefit. Is that something I'm going to argue for him? It's like, hey, cut this kid a break. You can see his attitude. He's got a good attitude. He's a good kid. He just had some weed. Rather than, oh man, don't watch that video. My client is a jerk. You know, what do we want me to say?
Right. Okay.
Makes my job much easier.
All right. Well, good. So I guess when I opened this up, I said we're going to be talking about marijuana and CBD laws. So I guess that's kind of the vogue thing now, I guess, when it comes to this is CBD. And so we can get into the questions and be specific, but what is CBD? What are the laws for that? And what do people need to be aware of when it comes to their possession of that?
So we're seeing these oils when it comes to vaping, for the most part here, and then we're seeing a lot of edibles. So there's two different types of oil. There's CBD oil, which is legal, which you can see in some of these smoke shops. You can find in the stores that are marketed and packaged professionally and sold in large stores, box stores, that are labeled CBD oil. For the most part, almost every single case, that contains no THC.
Yes.
It's completely legal. On the other hand, you have THC oil, which is a non-plant-based oil. It's not a green leafy substance. It's plant-based because it's an oil from marijuana plant. But it's charged differently because it's not a green leafy substance anymore. Even though it's the same active ingredient of THC, it's an oil. It's not a green leafy substance. So instead of misdemeanor amounts like you have with marijuana, it automatically, any amount is a felony. So the problem you're running into is these kids are getting what they believe is CBD oil that's been brought in from Colorado, from Oregon, from Washington, and they believe it's CBD oil, and it comes back containing THC. Well, now all of a sudden they're charged with a felony. And a lot of times they know, it's like, hey, this is some THC oil. But sometimes they don't. They think it's CBD oil and it's in fact THC oil. They get popped for a felony. And you're seeing that a lot with the high school kids, 19, 20, 21-year-olds that are thinking they have CBD oil and in fact it's THC, and now they have a felony arrest record. Fort Bend County has been really good with reducing those to misdemeanors because I think it's a change in the law that I believe is coming through the legislature, that it needs to be charged similarly to possession of marijuana because it's the same active ingredient. Mm-hmm. Same thing with edibles. You bring in edibles from Colorado, Washington, Oregon, that's oil. That's THC oil. It's automatically a felony, even though it's a Skittle-sized edible of THC. It's a felony. It has the same effect as marijuana. It affects you a little differently because of the way it's digested, but we're seeing that a lot, and these kids are getting felony arrest records, and it's because they don't know the difference between the THC and the CBD oil, and you can't tell by looking at it, and unless you're around it a lot. I talked to a law enforcement officer today, and he's like, I can smell the difference, but it's very, very, very distinct between CBD oil and THC oil. It's not very distinct. Sorry, let me back up. It's very subtle, and it dissipates quickly. He goes, I can tell the difference. He said, but the average person has no idea that it's THC oil as compared to CBD oil.
Does law enforcement have a way to test different oils on scene?
They do the same presumptive test that they have, and sometimes the CBD oil will test positive for THC. The lab will come back that it's negative, or vice versa. It'll test negative for THC, but they send it to the lab and it comes back positive. So I think law enforcement is trying to be very cautious with these presumptive tests on the scene because they are getting false positives, and vice versa. They're getting something to test negative and come back that it is containing THC, and then file on the individual later.
So what is the difference right now? Because I've heard there's CBD with no THC, and I also heard about Trump passing some laws or what have you that is going to allow CBD oil to have up to 3% THC. And I've even seen it where some of the local CBD stores are straight up marketing our CBD has up to 3% THC in it here locally. So is that legal or illegal?
Any amount of THC, 0.0001, is illegal. So if it is marketed CBD with THC, that is illegal. So now if federally, if they pass a law, that goes to federal law. That doesn't change state law. So the feds can say marijuana is legal. Texas has to say marijuana is legal. So we enforce state laws. DEA enforces federal laws. So a lot of these states where marijuana is legal, it's still illegal federally. But the feds are choosing not to enforce that law and allowing states to regulate the use of marijuana in their state.
So anybody, and I know a few people, I know a couple guys that have opened up some CBD locations here. I know a girl that sells it online or through some multi-level marketing thing. And for their sake, if they're listening, if they are marketing CBD that has THC in it, they are breaking a law if they're here in Texas.
Not marketing it. They can market it all they want.
If they're selling it or if they have it in their possession.
You are seeing some people market CBD with THC because it is much more effective, because THC is the psychoactive ingredient that gives you that high. CBD is mostly for medicinal purposes. It treats, anxiety, PTSD. They're seeing a lot of great information coming out for PTSD in vets. But the THC is the active ingredient that gives you that psychosis. So a lot of people market CBD with THC because that's what people want, but it doesn't contain any THC.
So right now, the ones that are saying it's CBD oil, but it has up to and I don't know why the number's 3%, but they all just happen to say 3% THC in it. So if in fact that product has 3% or any percent of THC, then they are breaking a law and it's a felony.
They can be charged with delivery of a controlled substance. Yes.
Or if they have a local store here and they are selling it on their shelves, then they are facing.
They could be charged with delivery of a controlled substance.
Okay.
Yep. If in fact that's happening, I would advise them to take that off their shelves and destroy it immediately.
Yeah. Okay.
Yeah.
Good.
So, does it happen? Absolutely. I mean, law enforcement may not have caught up with it.
And it's not like they're trying to sell marijuana or weed and break the law. They're
Right.
selling creams and topicals and eye cream and, stuff that's curing cancer. I get all that, but I think that a lot of people assume because Trump basically said he's not going to enforce it on a federal level, that it's okay to start selling it in Texas because it has 3% and Trump said it's okay. But
Nope.
actuality is that's a felony. You'll get locked up and you'll be charged with possession of a controlled substance.
That's right.
And that's a felony.
That's right.
Okay.
And, the officer I talked to today was saying that every place we've seen selling CBD oil is legitimate CBD oil without any traces of THC. What I have kind of been told and seen is you never can guarantee that CBD oil doesn't have traces of THC in it because it comes from hemp. And you have to be very careful in how you process it. So you got to get it from a reputable dealer. But again, if it's packaged, the ingredients are on it, then these big companies can't be manufacturing and sending products to a state where it's illegal because they're breaking the law. So they do a very good job in making sure there is no THC in their CBD oil. Now, if you're buying CBD oil on the street corner, there's no telling what you're getting.
Sure.
But if you buy it from a reputable location, and he even mentioned smoke shops. He says they're selling CBD oil, but every occasion we've seen it marketed in a reputable dealer, it is CBD oil, no THC in it, the times that we've tested it.
So when you have this happen, officer feels like that somebody's in possession of that. They stop. Most of what it sounds like is there's no way that they could know 100% that what they have in their possession is THC immediately. Like, it sounds like something that has to go to a lab and like something that you would know later on, correct?
Correct.
Okay.
I mean, unless it's an extremely experienced law enforcement officer and they can tell that very subtle distinction in the smell. I haven't seen anybody testify to that I'm aware of. I don't know if it's occurred, but that would be, I think, a very fine line. But I've been told by someone I find to be extremely reputable that he can distinguish between a CBD and a THC oil that's been vaped.
So if a cop pulls you over and you have CBD or THC oil on you, can the cop then test it and take you in if it tests positive for THC?
He can. I think they're being very careful about doing that because of the false positives. I mean,
and that's why I guess it's fairly new product.
It is.
It's not, weed, marijuana, joints, blunts, whatever. It is something kind of new to market. So they're kind of holding back a little bit on that.
I think so. I mean, in large part, my experience with law enforcement is they don't want to put anybody in jail for something that it may, because it's a hassle to get that taken off your record that, okay, look, it is showing positive for THC, but I know we've had some labs where it comes back and it's not THC, but we arrested the person and now he's bonded out, he spent money on an attorney, and we just dismiss the charges. We don't necessarily think that's fair. So I think law enforcement is very cognizant of, let's try to give some of these folks the benefit of the doubt and not put them in custody for a felony and spend all this money when we know sometimes it is coming back as not being positive.
What would you advise a client that has THC oil on them and they know it's THC oil and they get pulled over and the officer asks if they have any marijuana in the car? What should that person say?
It applies to on the scene, to at the jail, to, talking to law enforcement. You never, ever, ever confess to committing an offense.
Okay.
Because once you confess, the avenues that I have to help you are extremely limited from that point forward. So my advice always has been, look, I want to cooperate. I don't mind talking to you. I know you have some questions. My attorney advised me not to speak to you without him being present. I would love to talk with you later, as long as my attorney can be present, if you're okay with that.
Okay.
That makes sense to people.
Sure.
Like my attorney advised me not to talk. I'm not going to talk without him being present. Be polite, be respectful, and law enforcement respects that.
Mm-hmm.
I mean, they know. Law enforcement, if they get pulled over, do you think law enforcement's going to tell the officer who pulled them over, yeah, man, I got a pound of weed in the trunk of my car, man, I'm sorry. Of course they're not.
Right.
They're going to say, no, I'm not comfortable with you searching my car. I'd like my attorney being present. They get it. You know, they deal with it every day.
Okay. I guess in relation to the CBD and the THC, what about if you're somebody that doesn't have, I guess the same thing, I guess. If you have CBD and it's not THC, but you really don't know if there's anything in it or not, the same criteria apply there. If you think it's CBD and it's supposed to be CBD, but you don't know that for 100%, you're kind of questioning. Same procedure then?
I agree. Yeah, same
Okay.
procedure. I mean, you could say, I think if you can show you bought CBD oil from a reputable dealer, let's just say CVS for argument's sake, you have the package and it says CBD, and you have the receipt from CVS, and it comes back that it's THC from the lab, I would be really surprised if they prosecuted you for that offense. They may arrest you. You may have to go to court, but if I present that evidence to a prosecutor, I think they would be hard-pressed to prosecute you for that offense.
Okay.
Same thing we see with prescription drugs. You have prescription drugs, you don't have the bottle. You bring the bottle later showing you did have a prescription, it's the exact same pills you had in your possession. They dismiss those cases. I think if you have a good faith reliance, they don't have to dismiss it, but for the most part, I think they would.
Okay. Is it true that it's getting a little bit more lenient, I guess, in the state of Texas when it comes to medical marijuana and, I guess, possession? I've read that recently, within the last year or two, they've started to grant licenses to companies that are wanting to do medical marijuana here in the state of Texas. Is that accurate?
I think it's coming that way. I don't know if we have. I think we have some medical marijuana laws in place here. I don't know because I never see it.
Okay.
So I never see a medical marijuana case come my way because it's if they have it and it's with a prescription, then. But I don't think we. Let me back up. I don't think we have medical marijuana in Texas.
Okay.
I really don't.
Okay.
I think it's heading that way.
Right.
Just because of the studies that are coming out with PTSD and,
Right.
and anxiety and pain relief and
Right.
it's a whole list of things.
Okay.
It's going that way, but I'm not sure Texas has that yet.
Well, I
Okay.
think it should. I think Texas will be one of the last states to pass it, but
I do too.
I definitely think it should go in that way because
I
I've
do
heard
too.
many stories of how it's helped people.
And who knows? Maybe it was fake news, but I felt like I read that at some point that at least Texas was starting. I think it was like 3 companies starting to grant medical license for them to produce or sell, and so that's why I asked that question.
Gotcha.
One of the questions that I have, could be a multi-part question,
All right.
is related to punishment related. I think people out there that are smoking weed, what type of punishments are involved with the different classes, whether it's a misdemeanor, it's a felony 1, felony 2. Earlier you were talking about the different quantities
Right.
and what type of level they were at. So what are the punishments associated with that? And if you do get punished with that, what type of legal fees would we be looking at? Saying we the people.
Yeah,
I personally, I don't like weed. I don't smoke weed. But what type of penalties would the people be looking at, as well as, what type of cost associated with hiring an attorney to represent them, a good attorney?
Gotcha. So if you have the lowest amount, less than 2 ounces, for the most part now with the change in administration, I think we're going to start seeing you take a drug class, we're going to dismiss your case. So the lowest level offense of marijuana, if you don't have any priors, we're gonna send you to a drug class. You can learn about the dangers of marijuana, that it's not just some drug to play with, that it can have some dramatic effects on your life. We'll dismiss the case. I think that's going to change the fee schedule in Fort Bend County a bit because that wasn't available before. That you go take a drug class, we'll dismiss. Mm-hmm. So that'll, I think, decrease at least the low-level possession of marijuana fees. Typically for our firm, or a good attorney, not necessarily our firm, we are charged more on the higher end just because we're board certified or I'm board certified in criminal law. But you're looking at lowest level offense, $2,500. Once you get to a Class A misdemeanor, maybe $3,000 to $5,000. Once you get in the felony range, you're looking at, state jail third, maybe $5,000 to $10,000. Then when you start getting a second, first degree, it could be tens of thousands of dollars, depending on your criminal history, depending on, if we have an unlawful stop, an unlawful search that we have to litigate in court, and how much you have to lose. I mean, if you're a 2-time convicted felon and you're 25 to life, well, my fee's substantially higher for you because you're probably not going to take their 20, 25-year offer. We're going to have to go to trial and try to beat it. And then you get into trial fees that we charge separate and apart from the typical attorney fee us trying to work the case out. So you'll see a little bit of change in what we charge. I think that $2,500 for low-level offenses will decrease a bit because it's not much work to come in, and they're guaranteed essentially to take a drug class, and the case will get dismissed. We don't have to do much work on those cases. But once you get to Class A and felony levels, I think we'll play pretty consistent.
And Class A is how much?
2 to 4 ounces.
Okay. So basically, if you have less than 2 ounces on you, you're going to spend a couple grand to get out of trouble.
I think that's a fair bet.
And if you're going to have more than 2 ounces, then be prepared to spend a lot of money.
And it's weight-wise, a good perspective is your tennis shoe probably weighs about 10 ounces. So cut it in half, roughly, and
Okay.
that's about your felony level. If your weed weighs about what half your tennis shoe does, you're walking a fine line with being a felony amount of weed.
Okay.
So that's a good kind of rule of thumb.
Okay. With what's going on with Harris County in relation to go ahead.
I actually want to do it on the sandwich bag.
Okay.
Basically, if you've got a sandwich bag full of weed, you're going to get in some trouble. It's going to be expensive. If it's about halfway full, because you can typically fit how many ounces in a bag? Because people aren't weighing shoes, and I'm just for the audience that's watching.
Probably 2 to 3 ounces.
2 to 3 ounces in a sandwich bag.
Yeah.
So keep your sandwich bag under halfway full, and it won't be too expensive.
That's
for
right.
you. Okay.
That's right.
Cool.
That's good. No, I like that.
That's, wanted to give the people out there, keep it sandwich bag halfway full. You'll be all right.
But when you're talking about what Harris County is doing in relation to the ticket and that's for the first time. I mean, if in 6 months after you're found again, I mean, then it moves beyond that, right? I mean, this isn't every time you get found with less than 2, it's going to be that. I mean, it's going to pile up on you, correct?
I don't know that to be true. I think they're giving multi-time offenders additional chances when they get caught.
Okay.
With the low-level marijuana cases.
Harris County don't care. Have less than 2 weeds in Harris County. You get a ticket, you pay a fine, you move on. You don't have to worry about it.
Okay.
And I think Harris County, it's just the system gets overwhelmed at times with low-level drug offenses.
Imagine.
And, especially when it's legal, people are kind of starting to veer towards let's not spend all resources on those marijuana cases. So, I mean, I understand it in part. I don't agree with it, but I understand it.
Okay. So you are found to be in possession, and it's pretty high level as far as the amount that you have. He was asking as far as punishments go. I mean, when you're trying a case or you're helping somebody to try to get out of it and they made a really bad, stupid mistake, I mean, what typically are you looking at as far as what people are needing to do or what's the expected of them to help reduce their punishment, to remove it completely? Like what can people do if you ever get just that bad of a luck and you have that situation happen to you to try to help you get out of something like that?
So I think we're a little different than most firms is we try to be extremely proactive from the front end. So we spend a lot of time from the front end with our clients and trying to mitigate the damage that they're going to see in a couple months when they come to court. First and foremost is stop smoking weed. If you're arrested for weed, stop smoking. That's what we all want. That's what the prosecutor wants to see is, okay, you got arrested for weed, you made a mistake. Let's learn from that mistake. Let's make sure you're clean. Okay? Stop smoking weed. Mm-hmm. We're going to send you for drug test, and they're going to be random. I'm not going to tell you when I'm going to drug test you. I'm going to call you and say you need to get a drug test within 24 hours.
Okay.
Some clients like it, some don't. Don't hire me, but that's part of the deal. Is if you want me to help you, you have to cooperate and do what we tell you. Go get a drug test. Let's have 8 or 10 drug tests before we go to court to show you're clean. You know you made a mistake. You want to do the right thing. If you have a drug problem, we'll get you into treatment. If you got a weed problem, you can't quit on your own. Let's be proactive. Rather than I have 4 drug tests and we're reacting to that. Because then the prosecutor's like, well, he had a chance to go to drug treatment, but now it's taken 4 positive drug tests, and now he wants to go to treatment to try to stay out of trouble.
Right.
Let's be proactive. Tell me if you have a problem. I'll give you a couple drug tests. If you can stay clean, then you don't have a problem. If you can't stay clean, let's send you to treatment. So we're proactive in that approach. Is we need to send you to treatment. Let's get you there. And then it is just start gathering information to show me who you are.
Okay.
I want your resume. I want your high school grades. I want your middle school grades, your junior high grades. I want to know volunteer activity. I want to know if you have any extracurricular activities that you participate in. Are you a member of your church? What have you done for your church? Who's your family? I want to know all of those things because like we talked about last episode with Amanda and Phoebe, everybody has a story. Sure. I want to be able to tell that story, and I can't tell that story by talking to you for 30 minutes. I need material I can look at, and I can pick and choose what I think is a benefit to you and present that to the prosecutor.
Okay.
And we see that a lot when we try to get pretrial diversions, where it's a kind of a contract with the state of Texas, and you jump through some hoops and your case gets dismissed rather than it being an official court process.
Okay.
And I think it'll be much more prevalent now that we have a new administration as well. So we're very proactive and upfront with our clients when it comes to those cases, and that in the end pays off. But it's a lot of work for us up front.
Do you have any other questions that you wanted to hit on?
The only other thing that I think was related to home searching. We talked about probable cause and searching cars when officers come to your house, whether it's a party, you're loud, the neighbors call the cops, whether it's my kids, some are under the age of 18, some are in their 20s. What is the law, whether I'm home or not, as far as them being able to enter your property? What is probable cause? What gives officers permission or green light to enter your home without a warrant?
Okay. So they can search your car without a warrant because what we call an automobile exception. It's a movable vehicle. So they can search it without a warrant. Your house is not. It's not movable. You don't get the automobile exception. Law enforcement must have a warrant to search your home. There's some exceptions, but by and large, they must have a warrant.
So if I'm out front smoking a joint, they pull up, they see the weed, they cannot search my house.
In that circumstance, unless you tell them, I got the weed from inside the house, they can't search your house.
Okay.
So if what happens and what law enforcement can do is they come up to your door and they knock on your door. You open the door, they smell weed. That is probable cause. What the courts have held is they can come in your house, they can detain everybody in your house, and at that point, they can't search, but they can detain everybody to prevent anybody from destroying evidence. They then go get a warrant from a magistrate. They come back with that warrant. They search your house, recover the marijuana.
So they have to have probable cause to search your house.
They have to have a warrant to search your house. They have to have probable cause to enter and detain everybody inside of it. And sometimes they'll make a protective sweep.
If they enter it and see a pound of weed on the table,
they're going to get a warrant
to
get your weed.
Gotcha.
I mean, there's some exigent circumstances that they can search your house, and but by and large, they need a warrant. If they they see the weed, they smell the weed. Underage drinking, same thing. They can come in and detain everybody and get a warrant to try to find alcohol because there's underage drinking, a violation of the law.
Okay.
So, if you're smoking weed and you're having a party in the house, don't answer the door.
Yeah.
They can't come in if they don't unless they have a warrant.
But if you're smoking out back, there's nothing they can do about it.
Unless they smell it.
Well, if they smell it out back, is that considered in your house or is that in the backyard? Therefore,
that gives them probable cause to detain you and investigate.
As well as walk in through your back door if they want.
They have to have probable cause the weed's inside the house.
Okay.
To come in your house. So if you're on the back porch, I think it would be difficult for them to show that there's weed in the house unless someone says, oh man, our stash is in the bedroom closet. So again, don't talk.
Yeah.
And they won't get in your house.
Okay.
I mean, I think there may be some circumstances where you have extremely educated and experienced law enforcement officer that they could try to show that if they find somebody smoking weed at the back door based on my training experience, I've always found weed to be present in the house because that's where they store it and it's dry and climate controlled. You may be able to get there. I haven't seen it, but it's an argument I think they could make.
Well, and going back to the underage drinking, if I am home and I have a 18-year-old or a 20-year-old, anybody under 21, and I want to allow them to drink, and they are drunk, and the cops come to the door, and he's drunk, and he's 18, and he opens the door, even though I'm allowing him to drink, are the cops able to enter the residence for probable cause?
Is it your child?
Yes.
I think they can investigate if that's your child. I'm not sure they can come in. That's getting tricky. That's an interesting kind of what we call a law school question. That's interesting. I think they can investigate to see if he's your child.
If it's somebody else's child.
Now, having said that, if the 18-year-old answers the door and the cops are like, hey, step out here, or do you mind stepping out? They ask the question rather than ordering. Do you mind stepping out? And the kid steps on the front porch. That's public intoxication. If he crosses the threshold of the house, that becomes public. And so you'll see that a lot. That's a trick law enforcement does is you're being a jerk at the door, you're drunk, but nothing they can do. You have a right to be drinking inside your house. It's like, hey, man, look, you're not in any trouble. Do you mind coming out the front yard and talking to us real quick? We know we saw a problem down the street, and we need to see if you know anything about it. Oh, absolutely, I'll come out. All right, put your hands behind your back. Now it's public intoxication. Long as they ask the question and it's not ordering you outside.
I have been arrested for that before.
It's what we call PIP or
bullshit.
POP, piss off police.
Yeah.
You're going to go to jail.
Yeah.
That's
Okay.
probably a good story, I bet.
I bet it is. I bet that's.
I'm reading between the lines.
That's right. I bet it is.
Yeah.
Well, I think we've covered a lot. I hope we answer a lot of questions when it comes to marijuana and CBD, possession, punishment, cost, all that. I think it's been very valuable, the information. I know I've learned a lot as far as in the hour that we've been sitting here talking about it. So what we want to do at the end of every show, because just sitting here talking to you just whenever the show's on and we're just talking, you have a lot of good stories. So when we're doing these segments, I want to do it where we have a story time with Shawn, as far as just a story about a case, a situation, just something to give us hopefully some education. Just, I don't know. So
tell us a good story, Shawn.
Tell us a good story.
All right, so I'm going to give you the audience a great piece of advice, and then I'm going to tell a story where I think I made a mistake.
Okay.
So the best piece of advice I can give you is if you are pulled over and you have marijuana, do not try to swallow it, because that Class B minor amount of marijuana turns into a felony, tampering with evidence. Do not try to destroy it. Do not try to swallow it. Kids do that all the time. Oh, I can swallow this small bag of weed. It never works. Law enforcement pulls that out of your mouth or you choke. Now you're charged with tampering with that evidence with a felony, rather than just a minor possession of marijuana that you could have taken a class and got it dismissed.
Okay.
So don't ever try to destroy it or swallow it. It's going to end poorly for you.
Great advice.
Yes.
Secondly, I tried a possession of marijuana case, 3 or 4 years ago. And one of the tricks we often use is when law enforcement seizes marijuana, they must be able to prove in court that that's the marijuana in court was the marijuana they took from your pocket. And so a lot of times if law enforcement finds 3 or 4 bags of marijuana in a car, one's under the driver's seat, one's under the passenger seat, they have to be very, very careful that they label them correctly, and when they come to court that they can say that bag was under the passenger seat, because it's very hard to prove if you're the driver that you possess the passenger's weed under his seat. So if they can't say, well, this is the weed that was under the passenger seat, I'm going to walk you on that, because they can't prove you possess the amount that they have in court. They must match the weed that they found to the weed that they are bringing to court to show the jury that it's marijuana.
Got it.
So we had a guy who was found with marijuana, and I start questioning the law enforcement officer, and he brings a container that's sealed, labeled, marked with his signature, showing it wasn't tampered with. They open it, they pull out a small bag of weed. And I start questioning about the bag of weed, and I'm like, well, can you identify anything on this bag? Well, no, I can't. You didn't initial the bag that you found? Well, no. You didn't label it? No. So all you have is a Tupperware container that belonged to law enforcement that you put the weed in, and you can't say this weed is the weed you found because you didn't initial this bag. Well, that's correct. I didn't have a good faith belief to say that wasn't the weed. I know he didn't do what he was supposed to. He didn't label it correctly, but I had no evidence that it wasn't the weed. And so I didn't feel comfortable arguing that in closing, that this wasn't the weed that they found in the car. Because I'm essentially saying the officer tampered with evidence or planted evidence or did something to that effect, and I wasn't comfortable doing that.
Okay.
And they found my guy guilty, and I went and talked to the jury, and the jury's like, yeah, you admitted that was marijuana that they found in the scene. We would have probably found him not guilty because he couldn't prove that was the marijuana that was found.
Wow.
And in hindsight, I'm like, I can't believe I did that. I struggle with that because I probably could have walked my guy had I made that argument, but ethically, I wasn't real comfortable with it. And I've struggled with that. I think about that often, that I may have not done the very best I could have, but I think that was in a gray area that I wasn't willing to cross.
Well, now you know.
Yeah.
I bet you won't let that happen again.
I think I would probably argue it different. I still would be very careful with accusing a law enforcement officer of being unethical or incompetent without direct evidence of it. But
Well, a question pops up from that story. Excuse me. We're talking about bags of weed under the seats in cars. And if, a car full of kids gets pulled over, everybody throws the weed under the seat, which always happens.
Of course.
Who gets pinned for it? Who goes to jail? Who's in trouble? Who's not? What's the outcome of a situation like that?
4 people in a car, weed in the floorboard in the back seat. No one claims it. Most of the time, law enforcement's going to arrest all 4 and let the court sort it out. The risk you run if law enforcement doesn't arrest everybody is everybody says it was the guy that wasn't arrested. I mean, that's what they're all going to say. So you have to show an affirmative link. Do they smell like marijuana? Do they admit to smoking marijuana? Where was it found? Can you prove the driver had possession of marijuana in the back passenger seat floorboard? Whose car was it? How long have they been in the car? Again, do they admit to smoking marijuana earlier? There's any number of things we look at, and they'll charge everybody, but by and large, we get majority of those cases dismissed because in the end, they can't prove an affirmative link to one specific person.
So to give advice to a possible future client, if you're in the front seat with weed in your pocket, pull it out and throw it in the back. Pull it out of your pocket and throw it in the back seat and cross your fingers.
My first piece of advice is don't smoke weed. I think there's a lot of risk associated with weed that people don't appreciate, number one. Secondly, if you're getting pulled over, I probably wouldn't advise you start digging in your pockets. You're going to make a law enforcement officer really nervous.
There you go.
But the chances of me walking you on a case with the weed in the back seat is much greater than if it's in your front pocket. Let me say that. So, if you can safely get it out of your front pocket, I would highly advise that you do that.
Good to know.
Yeah, that's real good. But yes, just say no, kids.
That's it. Say no.
Well, this has been good.
Well, good. Thanks for having me.
So our next show that we're wanting to do is, I think, a show that'll give a lot of great information.
It's the one I'm looking forward to.
Yeah, I think it's going to answer a lot of questions that people have, especially here in the state of Texas, and that's gun laws, gun possession, gun ownership, LTC, non-LTC, carry. I mean, just the gamut as far as what we're going to do. So that's going to be our next show. And I say that because we want people who are watching this on Facebook, YouTube, wherever you're watching it, if you have a question in relation to what that show is going to be about, put it in the comments, send it to us, J. Weiss Marketing. Let us know what questions you have, things that you would like for us to ask Shawn, because we like to think that we ask really good questions, but people out there may be thinking of something that we aren't thinking of.
Yeah. So absolutely. I mean, I own a firearm business, as you know, and I still have questions. We take the classes, the LTC classes, you take the renewals, but, it gets foggy after 4 or 5 or 10 years. So there's, owning my own firearm business that you've been to.
Yes.
It's important, and I've got questions that I want to ask to give myself answers, to give the audience answers,
right,
and to know exactly what to do, what not to do. And
we'll get into a lot of self-defense issues too that we'll try to run through a lot of circumstances and what the law says, what you can and can't do, and how to keep yourself out of trouble. Real
cool. So as Grant was saying to the audience, if you have any questions related to gun laws, whatever that might be, leave a comment on any platform that you can reach us at. You can feel free to send direct messages, text me if you got my number, but leave some comments, ask some questions, and we will be sure to answer all of them in our next show.
Most definitely. Absolutely. Well, Shawn, again, man, this is great.
It's been a pleasure.
Yeah,
okay. I enjoy it. I really do.
This is
Grant.
stuff that
Thanks,
people
Shawn.
need to know, and because like we started the show off, people just don't know, and you got good information.
Well, let's go ahead and have a beer and tell us a couple more stories.
That's right.
All right,
Tell us
Turn
something
the
we can't
cameras
get on.
off.
That's right.
Yeah,
Absolutely.
exactly.
All right. Thanks.
All right. Take care, guys.
Yep.